Welcome to Ace Your RES exam. Feeling like Singapore land law is less a set of rules and more like this dense jungle trying to swallow you whole.
Yeah, I hear that a lot. Don't worry, you're definitely not alone there.
Well, consider us your expert guides for today. We're here to, chop through some of that jargon and get you straight to the stuff you need for exam success.
That's the plan. Land law can seem, well, overwhelming, but underneath it all, there are some fundamental concepts. We're looking at some basic land law notes today, and our mission really is to pull out the absolute essentials.
Exactly. Things you really need to confidently tackle those exam questions.
Ah,
So today, we're zeroing in on that crucial divide between proprietary and personal rights, what sticks to the property versus what sticks just to the person.
right, that's key.
Then we'll try and demystify ownership versus those slightly less all-encompassing lesser interests. After that, we're getting down-to-earth, pun absolutely intended, with real versus personal property, because knowing what stays with the house and what walks out the door is, well, pretty important.
Crucial, actually. Avoids a lot of arguments.
Totally. And finally, we'll unravel the sometimes head-scratching world of legal versus equitable interests.
Yeah, that one needs a bit of careful explanation.
Think of this as your, express elevator to land law enlightenment. No stops at the confusing floors today.
Okay, sounds good. So let's jump straight into that bedrock distinction. Proprietary versus personal rights. Get this clear, and honestly, a lot of other things start to fall into place.
Okay, let's unpack this. Imagine, right, you've got a verbal agreement to buy your neighbor's, prized durian. It's Singapore, after all.
Huh. Okay, a durian. Go on.
That agreement, that's a personal right. It's just between you and your neighbor.
Right, just the two of you.
Now, if your neighbor gets tempted by a higher offer and sells that spiky treasure to someone else, well, tough luck for you.
Yeah, you can't really force the new buyer to hand over the durian.
Exactly. All you can maybe do is have an awkward chat with your neighbor about the broken deal. Maybe ask for your deposit back if you gave one. It's like that first example in the notes with Ahmad and Hamid and the motorcycle that never quite materialized for Ahmad.
Precisely. Ahmad's right to get the motorcycle was only against Hamid, the seller. It didn't, magically attach itself to the bike when Hamid sold it to Fondi instead.
Okay, so Ahmad can only sue Hamid maybe for damages, like getting his money back, plus maybe a bit extra for the trouble. He can't demand the bike from Fondi.
Correct. His right was personal against Hamid. Now, let's flip it. What if Fondi, who did buy the motorcycle and is now the rightful owner, what if Ahmad, still feeling pretty annoyed, decides to scratch the paintwork on Fondi's new bike?
Ooh, bad move, Ahmad. Definitely not recommended.
Not at all. Because Fondi now has a right to his undamaged property, and that right is enforceable against, well, anyone who tries to mess with it, including a disgruntled Ahmad.
Ah, okay. So that's the core of a proprietary right. It's linked to the property itself.
That's it. It can be enforced against the world at large, not just one specific person. Think of it like the property itself has this legal force field around it.
Got it. Personal is like a handshake deal between people. Proprietary is like a power shield stuck to the thing itself, no matter who comes along. So how does this play out with actual land? Let's look at that condo example, example 1B.
Right. So Robert owns a condo. He lets his friend Michael stay in the spare room. Maybe Michael chips in a bit for bills.
Okay, a casual arrangement.
Yeah, very casual. Legally, that's probably just a personal right, a license to occupy. It's basically just permission from Robert for Michael to be there, between Robert and Michael only.
Right. Now, Robert sells the whole condo to Mary. What happens to Michael? Can he tell Mary, hey, Robert said I could stay here?
Nope. Mary wasn't part of that original buddy deal, was she? So Michael's right was personal against Robert. It doesn't automatically travel with the property title to the new owner, Mary. She can probably ask him to leave, reasonably, of course.
Okay, that makes sense. But what if it wasn't just crashing in a spare room? What if Michael had, a proper signed lease agreement with Robert to rent the entire condo for, say, 2 years?
No, that's a whole different kettle of fish.
Yeah.
A lease, a formal lease agreement for a fixed term, is generally recognized as a proprietary interest in the land.
So a lease isn't just a casual agreement then. It's got, legal muscles that work even on new owners.
That's a good way to put it. In that scenario, Michael's right to exclusively occupy the condo for those 2 years would bind not only Robert, but also Mary, the new owner.
So Mary would have to honor the lease. She couldn't just kick Michael out.
Generally, yes. She buys the property subject to Michael's existing proprietary right under the lease. That's the binds the world aspect of proprietary rights really showing up in real estate.
Okay, wow. The motorcycle and the condo examples really nail that down. Personal, just between those involved. Proprietary, attached to the thing, affects others. Makes sense. Okay, let's climb the property rights ladder then to this idea of ownership versus lesser interests. What's the big picture difference?
Think of ownership as having the ultimate power over a property. It's the complete package of rights you can have. It's like being the king or queen of the property castle.
Right, the VIP pass to all the property perks. So what exactly comes in this royal bundle of ownership rights? Our notes mention a few things.
Yeah, the key ones are the right to possess the property,
Yeah.
to actually be there, control it. Then there's the right to alienate it. That means sell it, gift it, transfer it.
Okay.
You've also got the right to enjoy it, live there, use it how you want, within the law, obviously.
Yeah.
Maybe have those karaoke sessions.
Within reason.
Within reason. Plus, the right to transmit it after you're gone, pass it on to your heirs. And crucially, the right to exclude others. To put out that keep out sign. That's the full owner's toolkit.
Got it. Own it outright. You hold all those cards. So these lesser interests then, sounds like someone else gets to borrow a few of those cards or rights.
Precisely. Lesser interests are specific proprietary rights that are carved out of that full ownership bundle. They give certain rights to someone else, while the original owner still holds the underlying title, the ultimate ownership.
Okay, so back to Michael and his lease for the whole condo. That's a prime example of a lesser interest.
Absolutely. Michael, as the tenant with that lease, holds a lesser interest. He has the right to exclusive possession during the lease term.
So exclusive, he could even tell Robert, the actual owner, to get lost if he just shows up unannounced.
Yeah.
Assuming the lease allows for that privacy, of course.
Exactly. Michael has the right to exclusive and immediate possession for that agreed period. It's a really significant right, even though he doesn't own the condo itself. He could sue a random trespasser, or yes, even Robert, if he interfered with his possession without a proper reason allowed under the lease or law.
Wow. Okay. And Robert's position while Michael is leasing, he still owns it, right? Just can't use it himself for that time.
Correct. Robert's position is often called ownership in reversion. He still holds the ultimate ownership, but his right to possess and enjoy the property is postponed until the lease ends. When the lease is up, all those rights revert back to him.
So ownership is like having the whole cake, and a lesser interest, like a lease, is letting someone else have a guaranteed slice for a set time.
That's a great way to think about it. And leases aren't the only lesser interests out there.
Right. The notes mention others.
Yeah, things like security interests, think mortgages or charges. That's the bank's right over your property if you borrow money against it.
Okay.
There are also rights of way, sometimes called easements, which might allow a neighbor to cross your land to get to theirs. And restrictive covenants, those are promises about how land can or cannot be used, like maybe agreeing not to build above a certain height.
Right. Those sound like topics for other deep dives, maybe.
Definitely. They have their own complexities. But for now, just recognize them as other examples of proprietary interests that are less than full ownership.
Okay, cool. Ownership, the whole shebang. Lesser interests. Specific, legally recognized slices carved out. Got it. Now let's tackle something that I think can really trip people up, especially when you're doing deals with real versus personal property. I mean, isn't it all just property, stuff you buy and sell?
That's how we often talk, isn't it? But for legal purposes, and especially for you folks preparing for the RES exam and working as agents, that distinction is absolutely critical. You need to be precise.
Why is it so important?
Well, because what counts as real property generally gets transferred automatically when you sell land or a building. What counts as personal property usually doesn't, unless you specifically agree it will. Getting it wrong leads to disputes.
Okay. So legally speaking, what is real property?
Real property is basically land, the buildings on the land,
Yeah.
and anything that's considered permanently attached or fixed to the land or buildings. These attached things are often called fixtures.
Fixtures. Okay. Like what? Give me some examples.
Think built-in wardrobes, kitchen cabinets screwed to the wall, central air conditioning systems where the main unit is fixed outside and ducts run through the walls. Things that are integrated into the building.
Right. Stuff you generally wouldn't rip out easily if you were moving. So those are typically included in a property sale.
Yes. Typically, they form part of the real property being sold.
Okay, so what's personal property then?
Personal property is essentially movable stuff.
Yeah.
Things that aren't permanently attached. Your belongings. Legally, these are often called chattels, Or sometimes fittings.
Chattels or fittings. Examples.
Your sofa, your dining table and chairs, your television, a freestanding refrigerator, lamps, rugs,
Mm.
things you can generally pick up and take with you.
Right. And these are not automatically included in the sale unless you write it into the contract.
Exactly. Unless the sale and purchase agreement specifically lists that the fridge or the curtains are included, the seller is usually entitled to take them.
Wow, okay. I can see how this is super important for an agent. You need to be crystal clear with both the seller and the buyer about what exactly is included in the price to avoid massive arguments on moving day.
Precisely. Imagine the buyer turning up expecting the fancy smart fridge they saw during the viewing, only to find an empty space because it wasn't specified as included. That's a bad situation.
Definitely.
So as future RES agents, understanding this distinction and advising your clients clearly is vital. It helps manage expectations and ensures the contract accurately reflects the deal. It's practical knowledge you will need and likely be tested on.
Solid advice. Okay, real property. Land and things stuck to it. Fixtures.
Yeah.
Personal property. Movable stuff. Chattel fittings.
Yeah.
Got it. Now, for our final hurdle in this basic land law session, legal versus equitable interests. This sounds a bit abstract.
It can seem that way initially, but it's another really important distinction, especially regarding how rights are protected. So first off, having an interest in land just means having certain legally recognized rights over it.
Yeah. Okay, like ownership or a lease or a mortgage. Those are interests.
Exactly. Now, a legal interest is generally the interest held by the person whose name is officially on the land register as the registered proprietor. The law formally recognizes this person as having the legal title.
Registered owner equals legal interest holder. This seems straightforward enough. So what's this equitable interest then, it sounds like? Almost the real thing, but not quite.
That's not a bad way to think about it sometimes. An equitable interest often arises when someone has a right to benefit from the land or has a claim against it, even if their name isn't formally on the title yet.
Okay, can you give an example?
The classic example is someone who has signed a contract to buy a property. Maybe they've paid a deposit, signed the sale and purchase agreement, but the whole transfer process, the registration, isn't complete yet.
Ah, so they're in that option to purchase or sale and purchase agreement phase, but haven't legally become the owner on paper.
Precisely. During that period, the law recognizes that the buyer has acquired a beneficial interest in the property. They have a legitimate, equitable claim to it based on the contract. The seller, while still the legal owner, might be seen as holding the property on trust for the buyer to some extent.
Okay, so legal interest, official registered owner. Equitable interest, someone with a valid claim or right to benefit, but not yet the registered owner, like our buyer who's paid the deposit.
Exactly. Or it could be the beneficiary under a trust, where the trustee is the legal owner, but the beneficiary gets the benefits.
Right. Now, what's the crucial difference in how strong these interests are? How protected are they?
This is the key takeaway. A legal interest, because it's registered and effectively public knowledge via the land register, is generally said to be enforceable against the whole world. It binds everyone.
Yeah, okay, strong stuff.
An equitable interest, on the other hand, while still a valid right recognized by the courts, has a slight vulnerability. It's enforceable against everyone except a specific type of person.
Uh-oh, who's the exception?
The exception is what lawyers call a bona fide purchaser for value without notice of the equitable interest.
Whoa, okay, that's a mouthful. Bona fide purchaser for value without notice. Break that down for us.
Okay, bona fide means acting in good faith, genuinely. Purchaser for value means someone who actually paid a proper price for the property, not just received it as a gift. Without notice means they had no knowledge, actual, imputed, or constructive of the pre-existing equitable interest when they bought the property.
So someone who buys the property honestly, pays for it, and genuinely didn't know and couldn't reasonably have been expected to know about someone else's prior equitable claim.
That's the essence of it. If such a person acquires the legal interest, i.e. gets registered as the owner, their legal interest might take priority over the earlier unregistered equitable interest.
Wow. So back to our buyer who paid the deposit but didn't register yet, holding an equitable interest. If the dodgy seller manages to sell again to an innocent second buyer who pays and registers first without knowing about the first deal, the first buyer might lose out.
It's a potential risk, yes. That's why completing the transaction and registering the legal title is so important. It provides the strongest protection. It basically puts the world on notice of your interest.
So getting that legal title registered is like putting up a massive legally binding mine sign that almost no one can ignore.
That's a pretty good analogy. While equitable interests are definitely important and have legal standing, the registered legal interest generally offers the most robust protection against third-party claims.
Okay. The notes also mention other rights quickly, like right of passage, temporary occupation, mortgagees' rights. These can be interests too.
Yes, these are all examples of rights that can constitute interest in land, and they can be either legal or equitable, often depending on whether they've been formally created and registered according to the legal requirements. And importantly, interests in land generally share three key characteristics. They tend to be irrevocable, can't just be taken back easily. They are binding on third parties, to the extent we just discussed, and they are assignable, can usually be transferred to someone else. Good points to remember for the exam.
Okay, phew. That was quite a mental workout, but honestly, super valuable for demystifying these core concepts. So just to recap quickly for everyone gearing up for the RES exam.
Good idea. Let's run through them.
We covered proprietary rights, the ones that stick to the property versus personal rights, which just stick to the person involved.
Yep, the condo lease versus the buddy staying over.
Then we distinguished full ownership, the whole bundle of rights, the whole cake, from lesser interests like leases, which are just specific slices carved out.
Right, like Michael the tenant having possession, while Robert retains ownership and reversion.
We clarified real property, the land and the fixtures, the stuff that stays versus personal property, the chattels or fittings, the movable stuff that usually goes unless agreed otherwise.
Crucial for avoiding those moving day dramas.
Definitely. And finally, we navigated the difference between legal interests held by the registered owner, binding the world, and equitable interests, like the buyer with a deposit, which are binding on almost everyone except that bona fide purchaser without notice.
Precisely. Mastering these fundamental distinctions is, well, I'd say absolutely essential for tackling the land law questions in your RES exam. They really are the building blocks.
Totally agree. So as you continue your exam prep, keep these core ideas front of mind. Picture that durian deal. Think about the built-in oven versus the microwave, and remember the security that comes with getting your name officially on the property title.
And always ask, who is this right enforceable against? Who can I assert this claim against, and what exactly can I claim? That helps clarify things.
Well, that brings us pretty much to the end of this essential deep dive into basic land law for your RES exam journey. We really hope this has shown some light on what can sometimes feel like a pretty murky area.
Yeah, remember, getting these fundamentals down is a huge step towards acing that exam. We sincerely wish all of you the very best of luck in your upcoming RES exam.
Absolutely. We have no doubt that with focused effort, you'll smash it. Good luck.
You can do it.
And maybe on that note, just a little thought exercise for you. Take a quick look around where you are right now. Can you identify things that would likely be considered real property versus personal property? It's actually a surprisingly helpful way to make these concepts stick. Until next time on Ace Your RES exam.